that the bar has also become a serious impediment in the way of justice, unfortunately. I've been dealing with several cases involving strikes by lawyers in different courts. In some courts, there are strikes every month. It's just decided that every month, in the last 2 days of the month, the bar will go on strike. Now, and unfortunately, it is not just the bar associations, it's also the bar councils which endorse such practices. There was this case that I had done where the bar council had issued a general notice to the lawyers that those lawyers who do not participate in the strike, disciplinary action will be taken against them. Now, this is totally, in my view, clear contempt of court, apart from being professional misconduct, participating in a strike. Bar Council, unfortunately, is a trade union of lawyers. And this whole business of self-regulation, Bar Council has been given disciplinary powers over lawyers who misconduct themselves. And Bar Council hardly ever exercises that jurisdiction in a fair or just manner. Usually doesn't do anything because they are people of their own fraternity. We have found that this whole business of self-regulation, whether it is in the medical council or whether it is through the bar council or even if it is through this in-house committee of judges, so far as misconduct of judges is concerned. This whole business of self-regulation does not work because there are various connections amongst lawyers, connections amongst judges and connections amongst doctors, and therefore the body of doctors or the trade union of doctors is unwilling to take action against members of their own fraternity. Same thing about lawyers, and unfortunately by and large the same thing we have seen about judges also. So for disciplinary regulation we need to have external bodies which are external. This whole business of self-regulation is a farce. It may sound very good that there should be self-regulation, but it does not work. I have seen that everywhere. And certainly lawyers have become a serious problem. Lawyers are not going to introspect. We as a society need to think as to what should be done to improve the quality of lawyers, to have proper systems of proper disciplinary mechanism for lawyers, etc.
Just to supplement, Prashant, one thing is that today's topic was not about the lawyers, so I have not spoken about that one. That was the one reason. But in pregnancy matters, I can say the maximum contribution is made by the lawyers. And I remember one instance when a junior advocate, that is son, told to father after when father returned, पापा वो जो राय साहब का केस था वो आज मैंने खत्म करा दिया जो 25 साल चल रहा था। पापा ने 2 दिए खींच के, उससे तेरी बेटी की बहन की शादी हुई है, तेरी शादी का तो उसको खत्म करा दिया। So they could not find that litigation to the end. And there are so many causes, one causes for seeking the adjournment. And he rightly said that in the state, like trade unions, advocates like this. And who will take action? That is the bar council, bar association, and that is elected body of the advocates. And there is politics. And next time they want to become the office bearer, so they will have to depend on advocates. They can't take any action. And judiciary is also afraid to take any actions about that one. But having the pendency, one thing is clear that the role is of the advocates. I agree with that one. And nowadays, the 5-year students are coming, youngsters are coming, and they are very hard workers. But I have seen so many persons who are not just mediocre or something like that. They want the success by all means. In my court recently I am telling you one example that one judgment was given in our tribunals against the person about the coaching, etc. So there were 2 remedies. One, to file the rectification application of that order, by miscellaneous application rectification order, and another was filed appeal in the Supreme Court. Mistake was actually so it was appealed in the Supreme Court. So both were pending. On 29th, it came before the Supreme Court, and Supreme Court order, interim order, pay such and such 10 crore rupees or like this, and tag it with such and such. Interim order was passed. By hiding that order, after a week, when the matter came in the tribunal, the rectification application, that order was not shown and relief was taken on the ground. For one reason that it was a time barred or something like that, technical ground it was taken. So this is the practice, and not by the youngsters, by seniors, but very reputed firm, law firm, who has a 90% work on that line. This mistake was committed by them. So this is one aspect. I was in New York, in America, and they asked me to speak about the pendency. So lawyers strike was one of the topic. Then I studied there and I found what is there, that every advocate has a license for 1 year or 2 years maximum on a particular court. If it is district court, then district judge will issue the certificate for 2 years only, and that will be renewed another. And for high court, separate certificate is required. Merely by advocacy registration with the bar council, that is merely advocate, but right to practice will be given by the judge of the court, the highest court, and the chief justice of the high court, whatever may be your district court or in wherever you want to do. And that is why they are keeping the discipline. They are maintaining. Here, once you got a license, that is a lifelong license from the bar council. You do whatever you like. So these are some problems which we can be discussed on next time on another seminar, and today's topic was certainly not about the lawyer system. Thank you.
It seems that somehow religious autonomy suppress human rights as well as fundamental rights. So what's your comment?
Religious?
Autonomy guidelines, I can say. Regulatory.
Is a correct judgment that, see, it's true that the Constitution gives you the right to practice your religion, etc., but does not mean that religious practices can violate fundamental rights of people. So therefore, if there is any religious practice which is violative of anybody's fundamental rights, whether of men, women, or anybody else, then certainly that practice cannot be allowed. So the right to practice religion does not mean the right to violate fundamental rights of other people or rights of other people. So that is clear.
Just to supplement him, this right of the woman who will be divorced by triple talaq or something like that was the topic. So she had a equal right, and I agree with him, and I agree with the High Court judgment that is there, and supreme, you can say what is supreme, that is the Constitution, and equality before law and equal protection of law, that is the spirit of the Article 14 of the Constitution. But finality will come from the Supreme Court, where matter is
At the same time, Article 25 to 28 wasn't there, was there in Constitution of India.
That is there, but that does not. Right to practice religion does not mean the right to violate somebody's other fundamental rights or other rights, etc. You can practice religion within those constraints. Thank you.
We'll assemble back in 5 minutes, and we shall assemble quickly over. Thank you.
Thank you.
For human rights issues, for women's rights, gender justice, rights of Adivasis, indigenous people. There's no end to the list of Sir's dedicated struggle at the Supreme Court of India to bring these issues to the court of justice of this country. May I now invite Sir to come over.
Thank you, Svetlana. Happy to be here today, and I'm very happy to meet some of my old friends. Many of them from my office, particularly Pankaj Sinha, who become such a active lawyer and activist, and he's also a representative of the Aam Aadmi Party in the courts. A lot of other friends, Ekta has started her own office, Tarek has started his own office, quite a few have done their own progress in life. I can see my friends from Sambhavana here. So, thank you Pankaj, thank you for calling me here today, and I'm very happy to be with you. These are very troubled times, as you can make out. Politically very difficult times, and times where human rights violations have reached the Everest of human rights violations. Very difficult times. Right from Kashmir to Kanyakumari, you can say the rule of law is broken down. Earlier you could look at national leaders and you could see some ethics in them, some morality in them, some guidance and direction. Your children could follow the example of Jawaharlal Nehru and some other leaders. Both parties, I don't say just Congress, perhaps even in the BJP, there were many very, very good leaders in the older generation. But today, if you look at Parliament, and today if you look at our members of Parliament, you realize that there is nobody in the country to whom young people can look up to and take guidance and say, I want to model my life along this person. I want to emulate this person. I want to follow in this person's footsteps. There is nobody. So it is Kali Yuga. Country has descended into darkness and the Rakshasas rule the country. Now when Rakshasas rule the country, the role of the lawyer becomes very important. Just as once upon a time they threw the British Rakshasas out of our country. Now in 2016, the time has come for us to rise in revolt and throw the Indian Rakshasas out of power. But it is not an easy task. It is perhaps easier to get rid of the British because they are white. Then the black and the brown will fight against the white. But when the Rakshas is himself black and brown, then to get rid of him is not a very easy task. And then the role of the Rakshas is to divide Indian society along the lines of caste, along the lines of communalism, along the lines of state, all kinds of divisions in society. As you practice in the court, you will see all the political controversies coming before you. Every single political controversy will come. Law is nothing else but life. And every dispute that happens in society will find a reflection in the court. Yesterday, the demonetization case was in the court. It's an economic issue, you might say. It's a policy issue, the Attorney General said, don't interfere. It's politicized, they say. But every issue that touches human beings, when it causes suffering, when it causes sadness, when it causes deprivation, it is a breach of your fundamental rights, your right to life. So every issue that comes in society, you can't breathe air in Delhi. You can't. Now it's impossible for children to grow up in Delhi. I have a 6-year-old daughter, she has breathing problems. Tarek has a little kid. Pankaj has a little kid. How will they live in Delhi? So you come to Delhi to make a life, to make a career, but you can't live in the city because it has become a gas chamber. Can it be corrected? Of course. Can it be changed within 6 months? Of course. But nobody has the political will, nobody has the political courage to do it. And therefore, my friends, we have come to a stage where, short of a revolution, there is no solution to the problems that the Indian people face. Short of an uprising like we had an uprising against the British, short of an uprising of the people, there is no solution to the problem. There is no piecemeal solution. I can go to court and do 100 PILs and get 100 orders, and it will come in the newspapers and everybody will say, Colin is such a fine lawyer, or Tariq is a fine lawyer, Pankaj is a fine lawyer. But all that is Maya, it's illusion. When you actually see what is the effect on the ground is zero. Not zero, but the effect is very minimal. Not zero. Public interest lawyers have a very important role to play. The moment you start